Okay, everyone, thank you for joining us this morning. It's a nice select group. Not everybody's taste, Building Safety Act, first thing in the morning. I hope that we can have some kind of interaction discussion at the end. As you probably know, what we've done is slides which are a little bit of a refresher, which is mostly what Paul will be dealing with. Then a few new cases, because there haven't been that many, but some of them are a bit interesting. And then moving on to what's on the horizon, which hopefully is going to be a flood of claims against the product manufacturers, who basically have more than contributed to the whole tsunami of claims that we've been seeing. So that's why we've called it What's Occurring. We're both Welsh as well. So we're having a bit of a throwback to a well-known TV programme. But yes, thank you for coming. Over to Paul.
Absolutely, thank you, Sian. As Sian says, we're both from South Wales, and either you get that reference or you don't, either because it's really relatively early in the morning, or you weren't watching TV in the noughties. Either way, if you want to discuss Gavin and Stacey with us, then we're happy to talk to you about that in the break. But the topic for today, of course, is the Building Safety Act. And I think it's worth just stepping back and realising that this Act is largely unknown by the vast majority of people in our country, but there is a significant minority of practitioners who have worked with litigation relating to building defects, whose practice it could radically change, and a number of litigants, many litigants, a myriad of litigants, whose experience of litigation will also change as a consequence of this legislation. It's of significance because of the principle of retroactivity, which is embedded within its terms. It's significant because it changes limitation periods that have been known to us all since we were undergraduates and have suddenly been transformed. And it's significant because it finds a way through, in principle, to the proper and fair allocation, one might say, of the costs arising from particularly fire safety defects, but of course building defects in general. It is, to a degree, a legislative revolution, and we all need to know about it if we're practicing, whether as construction experts, construction litigation experts, or professional liability experts. Now, as Sian has said, I'm going to give you a little bit of a refresher today about what the BSA entails. We're going to talk about the limitation periods, we're going to talk about the building liability orders and remediation contribution orders that the Act brings into play. And then we're going to talk a little bit about, as Sian says, the horizon, what's coming next. Unfortunately, any discussion about the Building Safety Act has to start with the tragic events of June 2017. And all of you will know about the Grenfell Tower scandal and tragedy in the Royal Borough of Kensington and Chelsea. What happened at Grenfell, of course, is known to everyone as a cladding scandal. But the reality is that the particular type of cladding that was used at Grenfell was the issue. It was an aluminium composite material, which some of you will be very familiar with, crucially, a polyethylene core. And this PE core ACM cladding became the centre of focus for the recent inquiry. Why is it so controversial? Well, of course, retrospectively, in hindsight, we now know that the problem with having this structure where you have a polyethylene core, high-density polyethylene core, with two thin aluminium sheets on the outside, is that when it's exposed to heat, the aluminium sheets delaminate. The HDPE inside heats up and is highly flammable. But it's not just the fact that the HDPE inside is highly flammable, it also leaks down the vertical building, heating up other panels. And that is why you had this huge conflagration at Grenfell Tower, and how within the space of a matter of hours, unfortunately 72 people had lost their lives. But, of course, the attention then turned to non-ACM cladding, and we saw the chaos that resulted from that in the leaseholder market, with lots of leaseholders trapped, unable to sell their properties or their interests in those properties, whilst at the same time unable to bear the extraordinary burden of remedying these fire safety defects. And the government identified that approximately 441 buildings in 2017 had this ACM cladding. And that's ACM cladding alone. It led ultimately to the independent review by Dame Judith Hackett. Now, if you've done any pleadings on this, myself and Siân certainly have, you'll know that it's quite frequent for Hackett to be quoted in the pleadings, because she went for the regulations essentially and the approved documentation that sits behind them. Now, the building regulations, as you'll probably know, set out functional requirements in Schedule 1 to the regulations. They set out high-level, outcome-focused objectives when establishing fire safety in respect of any building. But the real content, the real meat that people focus on is within the approved documentation, ADB. And Hackett said, well, these regulations aren't fit for purpose. They just don't work. They're not providing the certainty that people need. And ultimately, it leads to a game of finger-pointing, which we saw quite quickly in the Technology and Construction Court, with a slew of claims, tidal wave we've called it there, relating to fire safety defects, but also then the other building safety defects that emerged following proper investigation and interrogation of works undertaken in these high-rise, particularly high-rise buildings. So fast forward to the Building Safety Act. Now, everyone will be aware that the Safety Act came as a consequence of huge political pressure, primarily, although not solely, primarily within the leaseholder market, for the government to act to ensure a proper and fair allocation of costs arising from fire safety and building defects. It's enacted in 6 parts to address the safety of people in or about buildings and improve standards. But it also creates new causes of action and new instruments. And these remediation contribution orders, RCOs, BLOs, building liability orders, we'll be looking at in a moment in a little bit more detail. Critically though, as I've already mentioned, the changes to limitation periods in the Defective Premises Act 1972 in particular. And we're going to have a look today briefly at the decision of the Court of Appeal in BDW and URS, and Siân is going to look a little bit at the FTT decisions that have followed on relating to BLOs and particularly RCOs. Let's turn then to the duty upon which the Building Safety Act really hinges. It piggybacks on the pre-existing duty under Section 1 to the DPA 1972, which states that a person taking on work for or in connection with the provision of a dwelling owes a duty to every person who acquires an interest to see that the work which he takes on is done in a workmanlike or, as the case may be, professional manner. Critically, to ensure that it's fit for habitation when completed. And Parliament decided that this was the duty, the fit for habitation duty, upon which the Building Safety Act extensions would hinge. There is also, though, a new Section 2A that's inserted within the DPA 1972. Bear in mind that in relation to Section 1, the duty applies to the provision of a dwelling, new buildings, essentially. This new duty under Section 2A applies when you refurbish buildings, but it's only prospective. The extension of the limitation periods is the most sizable change that comes about as a consequence of the 2022 Act. And this is absolutely critical. It extends limitation for buildings that are completed prior to the 28th of June 2022, which was the date of commencement of the Act, by 30 years. That's a substantial change to limitation periods for actions relating to building safety defects. And let's just pause there. I don't think lawyers, let alone organisations that are involved in the provision of dwellings, have fully comprehended the risks that this exposes them to. That may also be true not just of private parties, but local authorities working through private limited companies to build things like social housing. This is a huge risk prospectively that emerges due to buildings being built since essentially 1992. In relation to buildings that are completed after the 28th of June 2022, it extends the limitation period by 15 years. So another long shadow still being cast over developers and the like due to that extension. We'll come on to URS Corporation Limited and BDW in a moment, after Sian's spoken about a couple of issues. But in relation to URS, the key question, just to pose it for you here, is what happens if you've got continuing litigation that was commenced in proceedings that were issued prior to June 2022, and you want to rely upon these new DPA limitation periods? Well, the answer is now, at least for the time being, relatively clear from the Court of Appeal, and I'll come on to it in a moment. Now, this is the bizarre conundrum provision within the Building Act of 1984. Section 38, if you Google Section 38, there are various opinions on whether or not Section 38 is even in force. And I'm no doubt there are many lawyers trying their best to establish what the position is. It was anticipated that this actionable duty imposed by virtue of breaching the building regulations such that it causes damage. This gave, in principle on paper, private individuals the right to claim damages for building defects that were breaching the building regulations. But it was never enforced. Parliament never brought it into force. It's just on the statute book. Now, the government issued a paper, I think in around 2022, maybe a little bit earlier than that, in which they proposed using the Building Safety Act to resuscitate Section 38. And so there are lots of people still out there who think that this provision is still, or is indeed now in force. It's not. And that's why what we're going to tell you about the limitation period. You see up there, there's an extension to 15 years under Section 4B of the Limitation Act 1980. That remains on the back burner. It's one to watch, but Section 38 is probably the main conundrum provision here. Building liability orders sound quite dry, but are actually very, very interesting. Let's just take a step back and ask ourselves, what were some of the big problems when dealing with allocation of costs for remediating building defects, and in particular building defects arising from fire safety issues? One of the big problems was that many providers of dwellings under Section 1 were using special purpose vehicles to shield themselves from the risks of exposure to costs and litigation. And initially, the thought was, well, we'll try and get rid of these SPVs by making sure that you can bring actions against the companies behind them. The building liability orders, however, that are set out in sections 130 to 132 go much further than that. They effectively emasculate the corporate veil, the company veil, for the purposes of seeking costs for remediation of these sorts of defects. They blow a massive hole through the concept of the corporate veil, and I'll explain why by reference to section 132. You can see there that a BLO is defined as an order providing that any relevant liability of a body corporate, defined as the original body, relating to a specified building is also a liability of a specified body corporate, or a joint and several liability of two or more specified bodies corporate. Now, that is a lot of jargon, but essentially it means you can seek to pin liability on corporate entities that sit behind the body corporate. And a really hot topic, which we'll come on to in a moment, is what is an associate? How do you define an association between commercial entities? It is necessary to satisfy certain conditions in order to pin liability by way of a BLO, but there's also this discretionary element to it, and the High Court must consider that it's just and equitable to make a BLO. And as we've said there, the problem that it was initially, at least ostensibly, designed to resolve, the Act goes much further than that. It's quite a significant change to the concept of the corporate veil. So we can see here that one needs to define a relevant liability, and the Act does that for us. It says that it's a liability that is incurred under the DPA 1972 or Section 38 of the Building Act 1984 as a result of a building safety risk. So it's not, again, limited to fire safety. We've noted there that liability isn't defined here, but we've provided our opinion with the disclaimer, of course, that you'll need to come back to us if you actually have a case on this. We think that probably this will include court judgments, arbitration awards. It probably won't include adjudication decisions due to the lack of finality, but liability under settlement will probably suffice. And building safety risk, again, is defined much more broadly there, as you can see, than merely being confined to fire safety. And this is the most controversial aspect, I think, of all of these changes. The cause was undoubtedly Grenfell. That was the trigger for all of these changes. But it now radically changes the landscape of litigation relating to building safety defects in general. And you've got to establish liability of the original body. Relevant liability must be that of a body corporate relating to a specified building. How do we define association in the relevant period? Well, because the body corporate has to be associated with the original body in the relevant period, where relevant period means any time between start of works until the making of the order. But it's not enough to be associated via person. You need to establish some degree of, I suppose one might call it corporate association, in order to get within these provisions. An association for the purpose of section 131 means one of the associated bodies controls the other, or a third body corporate controls both of them. So this allows us not just to get to the vehicles behind a developer, let's say, but it also allows us to get to the heart of a group of companies, including parent companies, if the court thinks it's just and equitable to do so. And control is the critical thing. For the purpose of both these building liability orders and also the remediation contribution orders, which we'll come on to look at in a moment, control is critical if you want to prove this association. Now, I'm not, because we're all eager to hear what Siân has to say, I'm not going to take you through all of this, but this is how control is defined under section 131. Under a company, a limited company, one's looking at issued share capital or the exercise of voting rights. And of course, in relation to a limited liability partnership, the concentration really is on majority voting rights. But this will, of course, be incredibly fact sensitive when you're seeking to establish control for the purpose of BLOs. And in relation to discretion, it's easy to sort of sit back and say, well, the Act doesn't define what just and equitable means, but we've all had experience in one way, shape or form of this phrase, just and equitable. It's used in the Civil Liability Contribution Act, it's used in the Financial Services and Markets Act. There has been commentary on it in this case of Reclinvest PLC. By and large, I don't think this is going to cause people too much concern. Just and equitable is a phrase that lawyers tend to know when they see it, but of course, again, it's going to be very fact sensitive. And what will be interesting is to look statistically at how frequently these BLOs are actually being granted by courts and in what circumstances. Perhaps that's a topic for next year's talk. So what does this affect? Well, I've already said the Court of Avail, we've said lies in tatters, at least for the purpose of BLOs and getting to the company behind the corporate body, it does lie in tatters. We also know that it allows us to target group company arrangements, and it allows, of course, us to expand the potential range of defendants. It is an opportunity for some and a huge risk for others. Moving on then to remediation contribution orders, this is a slightly different arrangement and it involves the FTT in quite a substantial way. You'll remember that, of course, a big problem emerging out of Grenfell was the fact that leaseholders were trapped. We mentioned this earlier. And, of course, part of the Building Safety Act was about trying to remedy that market. And one of the big concerns was that leaseholders were going to be essentially held responsible for remediation costs arising from building safety defects by virtue of the service charge provisions within their leases. And this whole regime is designed, we'll see how effective it is at doing it, to address this sort of problem. Leaseholders, as I said, liability for service charge under relevant leases can't be used to claw back costs of remediating historical safety defects. Remediation orders under section 123, the regime permits the FTT to provide an order requiring a relevant landlord to remedy specified relevant defects. That word again, specified relevant defects, in a specified relevant building by a specified time. We'll come on to that in a moment. And we also then have remediation contribution orders that require specific body, corporate or partnership to make payments for costs incurred in remedying relevant defects. Now, again, one can expand the application of the RCO regime to associated persons using what are similar control mechanisms under the BLO regime. Now, again, I won't go into this in too much detail, but one has to define relevant building, qualifying lease and time, and these provisions are not too complicated, but require some careful thought in any given case. A relevant building is a self-contained building or part thereof of 2 or more dwellings, at least 11 metres high or at least 5 stories. Now what's critical to note there is this notorious marker has always been anything above 18 metres. We're now not just talking about high-rise buildings when we're talking about RCOs, we're also talking about medium-rise buildings. Of course, one needs to establish that it's a qualifying lease within a qualifying time, but it's also critical to remember that the lease is the thing that satisfies and qualifies under these provisions rather than the lease holder. Bear with me a second, I've gone ahead of myself, there we go. Relevant defect is defined as arising as a result of anything done or not done, or anything used or not used in connection with the relevant works causing a building safety risk. Again, not fire safety, building safety risk. Relevant works relating to the construction or conversion of the building, works undertaken if the works were completed in the relevant built period or afterwards to remedy a relevant defect. And the relevant period is 30 years ending with when the section came into force. So we're dealing again with the 30-year period that we saw under the DPA amendments. Now, association under RCO, the RCO regime, has been looked at, but we'll come on to that in a moment. Section 124 sets out what orders the FTT can provide. Requires a specified body, corporate or partnership to make payments to a specified person for the purpose of meeting costs incurred or to be incurred in remedying relevant defect relating to a relevant building. And it's pursued by an interested person. That could be a local authority, an FRA, or person with legal or equitable interest in the relevant building or part of it. And section 121 sets out the sort of definition of associated persons. And I don't think, again, we want to get into the detail of this, but it's important to remember that the test for association is very specific under section 121, and you'll need to satisfy this test for association, but you also then need to satisfy the control tests as part of this association test that we saw in respect of the BLO regime. Now, we're going to turn to another hot topic now with Siân talking about claims against construction product manufacturers.
Yes, thank you, Paul. This is probably my favourite bit because they're on the horizon, and it would be nice to find that these parties finally do get involved in paying for what everybody else has been paying for up to this point. And the claims against the manufacturers had, to my mind, been given this new lease of life when the BSA was passed, and we got these new brand new statutory causes of action, all very exciting. And meanwhile, we had lots of actions coming through the TCC, mostly settling, because that's the way things are. And all of these insurers for the professionals were paying out, and I kept thinking, any second now, people are going to be launching the contributory recovery claims against the product manufacturers, and there was a lot of silence. The reason I think there was silence for quite a long time is that these causes of action in the statute are very hard. They came along with a big fanfare, but actually when you attempt to make out on the facts of your case whether you get a cause of action under the statute off the ground, I find myself looking and thinking, I'm better off with my old ones. You know, misrep, misstatement, duty of care, owed a warranty, things like that. And what we're seeing, as I'll come to in the end when we chat about the few cases that are currently pleaded on it, is that the Building Safety Act is in there, but it's pretty much like an also-ran. It isn't spearheading it. That's the impression that I get. Is it this one here?
Yes.
The new statutory cause of action requires you to go and define the construction product manufacturers. Fine, you can do that. That's not hard. We all know who they are. Bear in mind that there are the corporate structures as before. So you would be looking to make out wider spread if you need to, because the target company, the one that actually supplied, may be one adjunct behind a complete corporate governance structure set up for tax benefit purposes, not necessarily all based in the UK. But they are the person who markets or supplies a construction product. And again, it's the economic operators. You've got some widening words that you can use. Then you're looking at that they missold inherently defective products or products that breached existing regulations. And this is where it starts to get quite complicated, because you are looking for the things that they did wrong in 3 sets of regulations, 2 of which are Euro regulations. And I don't know about your experience of European legislation, but mine is that it always seems a bit grey and not very specific. And it then has a number of sub-regulations that you have to refer to. So again, it's quite complicated. But assuming you can get past that stage, this is Schedule 11, where it points to the Construction Product Regulations 1991, the EU Regulations 2011, and the EU Regulations 2019, because of course we're no longer part of the EU, we have the special amended regulations. That has to then cause economic loss, and this is interesting because, you know, recovery of economic loss and tort is not that easy to achieve. It's gate-kept by long-standing case law and public policy. This makes it very clear that you will be able to claim damages for economic loss, and it puts it absolutely straight up in the statute wording. So much so good. Then you get to the conditions for application. That's set out as A to D in section 148 and the subsections 2 to 5. And so you trickle through these and you have to achieve each of the conditions. So condition A, that they failed to comply with the construction product requirement. That's a defined term. You have to go back to the statute to find out what that means, and it basically means failure to comply with one of those regulations that I've just mentioned. Person who markets or supplies a construction product makes a misleading statement. So this is the other route. Besides failure to comply with the regulations, they've made a misleading statement in relation to it. Now, if you've been involved in these cases, you will have had many instances where you will have seen the product literature that came out alongside these products. And within that product literature, there were repeated statements like, oh, it's class 0 and it's fabulous and you can use it, it's perfectly safe in buildings that are tall buildings. But then within the same document, you also have statements which say things like, it's certified under BBA for the construction that was tested. And that is the key thing. They have set up certification on their product in a certain structure which requires the same components to be present in your subject building before the BBA certification applies. And the kicker in it is what they have used for that construct is products no one uses. literally no one uses Marley Interit as a cladding product. And so one of the product manufacturers will have used that. So nobody has got a direct hook into the BBA certification. But you'd have to really be reading that promotional literature like a forensic lawyer to work out that there is this massive stumbling block. And I'll come to it later, but I have a feeling that the next slightly more evolved category of claims against these product manufacturers will be saying, you deliberately did this because you knew, and we know they knew because they've had to say in the inquiry, you knew that your product was not safe. You knew it wasn't safe, but you knew also the UK regime was going to let you carry on promoting it because, shall we say, it was a bit lax by comparison with Scotland. If you know the history of all these fires, there was a big fire in Scotland prior to all the ones we know of now, and that resulted in a change of the building regulations in Scotland. So there was the opportunity, there was the remedy, it was taken by the government in Scotland, but they are a devolved government, so the UK did not do it. Lots of things like that led these companies, which, as I say, are not all based in the UK, or even mostly not based in the UK, realising that they could carry on pushing this product into the UK market, which would be rejected in Europe, Scotland, Ireland and America. Doesn't mean they weren't pushing other products which have caused other problems, but for the purposes that we're in, that misleading statement point may come back as a significant route against the manufacturers. A person who manufactures a construction product that is inherently defective, I mean, again, quite a difficult thing to prove, what is inherently defective. Clearly, we're into the realms of expert evidence. You know, each time you've got to go through one of these interpretation stages, you're hitting a risk on the case. Can you get over that problem that you have to prove it? Condition B, so if you get through one of those, you've got the A, B, and C. Condition B is that after you've done that product is installed in, applied or attached to a relevant building in the course of works carried out in the construction of or otherwise in relation to the building. So it's not just construction, it's also refurb, because the Grenfell Tower event was a refurbishment. So again, condition B, you probably achieve that because otherwise you wouldn't be looking at this cause of action. C, that when those works are completed, in a case if the building consists of a dwelling, the building is unfit for habitation. Now, unfit for habitation is a phrase I bandy around, we all bandy around like it's an obvious meaning. But actually, the leading case is Rendlesham. It's hundreds of paragraphs long. It's got matters which concern leaks, dripping walkways, other aspects of the building that didn't work. But you have to go into the detail of the paragraphs. And in there, in the 200 pluses, there's a paragraph that talks about the dividing walls not doing their job. And that's the hook into fire safety. Literally one paragraph from Rendlesham, because it isn't talking about fire safety defects, it's talking about a different form. People always say, well, Rendlesham tells me it's going to be okay, but when you actually come to running a case, the parties that are defending will point out you've still got to prove unfit for habitation. And of course, you are possibly years after the construction, many years even after the discovery. And where are all the dwelling owners? They're still living in them. And that's one of the strongest things they say back. If it was so unsafe, why are you still living there? If it was unfit for habitation, why do you remain there? There is an answer back to the, oh, we've all been doing the waking watch, which is what makes it safe, or we've changed the alarm system, so it's much quicker. Or the reaction to a fire is no longer stay put, it's evacuate. All of those things mean that the building is now temporarily fit, but it doesn't mean it was fit at the point of completion. One or more dwellings is covered in the section. Then we come to section D, that the facts referred to, i.e. in A, B and C in the previous page, were the cause or one of the causes, which of course is a saving grace, it doesn't have to be the only reason, of the building or dwelling being unfit for habitation. So you've got the layers, but you've only, every layer that's built up, so this is no get out for the product manufacturers under the statutory scheme if there is another cause. But of course, they will be saying, no, the building's not unsafe because of my product, it's unsafe because you didn't put the cavity barriers. If you'd put the cavity barriers around the windows as you were supposed to and at every floor, the building would have been safe. I've had personal experience where that has become the fighting ground. And unless you've had a very invasive interrogation of the building to demonstrate why that didn't arise, because you're talking periods of 20 metres gap to be able to meet the requirements under the building regulations. And you might have a floor in between there, or you might not. If you've got a duplex, you don't have a floor, so you don't have a cavity barrier there. So that's another difficult part to prove that it is one of the causes. Who can bring them? Well, anyone with a relevant interest. And this gets interesting because it means not just the owners, or people who we think of the owners, freeholder, long leaseholder, but also potentially the building owner, somebody with a shorter lease, property company. Quite a lot of buildings that have dwellings under leasehold will also have a property company where all of the leaseholders also hold a share in the property company or the management company. So it's a little bit easier to get past that stage. That they've suffered a loss, well, usually it's the fact that they are either unable to occupy or unable to rent, because if you've got a building that's subject to problems of fire safety, in theory you shouldn't be letting it because you don't meet the requirements of a separate act, the Landlord and Tenant Act. And again, that gets raised back when it says, well, you've got all these people who are still letting their property, they're all in breach of the Act. Why don't we just let their tenants sue them for breaches of that Act? Repair and reinstate and meeting the fire safety requirements. Mostly, I thought these claims would be that the insurers who had paid out on professional indemnities would use their rights to step in and subrogate, and that they would be pursuing these claims. I think that is what's happening, but it's happening sotto voce. We're not necessarily seeing a great deal happening on this front. The route for the contribution claim, of course, you can do it via the same damage. It's unfit for habitation, and we've got the cladding products and past defaults, so we've got the benefit of the additional limitation period. It means that there could be quite a long time for evolution of these claims. You know, we're still very much in the early days, even though we're 7 years post-Grenfell, even though we are mostly coming through the claims against the insured professionals, we've still got the whole of the leaseholder sort of category of claims. And as Paul was saying, they're coming via the FTT. That's the first tier tribunal, which is the first tier of the property tribunals. I, for one, have never appeared in the property tribunals, but originally when this was happening, I did wonder what was happening in the leasehold tribunals, because it's where you go for all disputes about leases. And one of the biggest disputes that was happening was these leaseholders saying, do I really have to pay for all these fire safety defects because I can't afford it? I bought a cheap property and now I'm being presented with a bill that's 20, 30, 40, up to 50% the value of my property. Originally, the first tier tribunal decisions were saying, well, it's a contract, you entered into it. If it's claimable under the service charge, you have to pay it flat. No help at all. But the BSA has come in to help those people a lot. Right, so what's occurring? This is where I'm going to hand back to Paul to deal with the case of URS against BDW, which is a Court of Appeal decision, so it's an appellate and worth knowing about, and it does cover some quite meaty points.
Yeah, absolutely. So what happened in this case? Well, BDW, of course, is a huge developer. All these Barratt homes that you know about have come under BDW's wings, and BDW engaged URS as a structural engineer to design various buildings up and down the country. Just like many developers, after Grenfell, BDW started an investigation into these buildings that it had been responsible for, And lo and behold, it found numerous building safety defects in many of these premises. The question arose after issue, where you have this new statutory regime which allows us to go back 30 years for the purpose of limitation under the DPA. The problem for BDW, or the seeming problem, was that proceedings had been issued in March of 2020. So the question and the battleground before the Court of Appeal was whether or not you could seek contribution from URS, whether you could bring them into the proceedings, despite having issued prior to the Act coming into force on the 28th of June 2022. And the court was pretty clear on this, said that actually, yes, you can bring them in. The new 30-year time limit was intended to apply to proceedings that had commenced before the Act came into force. So there are essentially two stages to the limitation and retroactivity inquiry. The first is, well, can you force the limitation period back as far as 1992? The statute clearly says yes to that. The second question is, well, what about bringing litigants into proceedings that are already extant, already existing, at the point the Act came into force? And the Court of Appeal was quite clear on this as well. They said there were no limitations imposed by the statute that would prevent that statute applying in, and I quote, ongoing proceedings. But in addition, they commented on a couple of other principles applicable in this case. So they concluded the developer can both owe and be owed duties under the Defective Premises Act, which is quite an expansion to our thinking about the DPA and how it works. They also said, critically, that developers can make claims for contributions despite the fact that they had no proprietary interest in the development at the time the remedial works were carried out, and before the owners had brought proceedings against the developer. So URS Corporation Limited again represents a huge additional risk for various parties who are engaged by developers prior to the 28th of June 2022 to provide dwellings and or refurbish dwellings. However, we've noted there that this isn't the end of the matter. There is an appeal outstanding, or at least was, in the Supreme Court as of the 6th of February 24. So we need to watch this space. It may be, because of the controversy around this decision, that is overturned. Although offering a view, I think given the extensive nature of the new legislative regime and the clear political will behind it that has obviously informed the drafting of the statute, I hazard a guess that the Supreme Court would probably agree, at the very least, on the ongoing disputes point when the matter comes before them. But you can give me a call if I'm wrong about that.
Yes. I mean, I think it will be upheld, partly also because it was an expert court dealing with it in the Court of Appeal. As you know, there's now 2 former TCC judges sitting in the Court of Appeal. They are, I don't think the Supreme Court will feel that it should unravel what has been considered by experts whose background is appropriate to the case. The consequence of it possibly being upheld, it occurs to me, is actually really far-reaching. If you've got any proceedings which have been issued prior to it coming into force, and you don't consider, at least consider, whether it should be amended to add this cause of action, query whether we're going to have a new species of construction solicitor's negligence. That's the kind of thing which won't yet have happened by the time the Supreme Court hears this case. Because if the Supreme Court was hearing the real effect of your incredibly sweeping retrospective decisions here, which are nicely done and very clear and very justifiable at the Court of Appeal, if you're not seeing the consequence, the second wave satellite litigation that follows, you won't necessarily have it brought home to you. It will depend who intervenes, or if anyone intervenes at the Supreme Court. But it occurs to me that prior to the Act coming into force, no lawyer would have known of its existence, so you wouldn't have considered it. So there may be many cases out there where you advised on the basis of there's no remedy, you're out of time. And if things have settled because of that advice. That's the end of it.
Yes.
If it's been settled and concluded, that is the end of it. But what if it never got settled? What if it's just gone quiescent and limitation is still ticking and you've got this long period of time? And meanwhile, the person who received the advice, which was perfectly correct at the time, doesn't go back to another lawyer. And then later on, they do go back to the other lawyer, but for some reason in the intervening period of time, something's happened, like they can't demonstrate the loss or whatever. That other lawyer who advised, but now knows there was a change and doesn't go back and review and warn the clients that actually limitation has changed on your case, you may wish to reconsider. You know, this is all new. Is there a duty to advise at that point? You know, we all know, as well, in our set, we do a lot of solicitors' negligence on construction negligence. And I sometimes look at that from the perspective of the solicitors who is dealing with the case and has given perfectly proper advice. What duty is there to revise what you've said? You know, it's very easy if you see a client regularly to say, actually, you know that case you had last year, did you ever settle it? Because there's now an extension to the limitation period. Maybe that would require revision of that advice. And I certainly know that's one in the centre. I would have advised in the past about that very developer in that position. You know, what's my chances of being able to recover when I gratuitously, with no claim coming at me, decide to remedy the building? There is in fact some old case law which basically says if a builder goes back and does remediation without having to, they are entitled to recover the costs of doing it. It's kind of like a quantum meruit argument, but the position for the developer who, for reputational reasons, does not want their building to be tarred along with the others as non-compliant, accepts that they just need to get the cladding off and just gets on with it, and then is subsequently looking at recovery actions. You know, it's completely changing what you used to consider, you know, contract or statutory. You know, it's run roughshod over it. Whether all of that will be in place for the Supreme Court, no idea.
And Sian's just triggered a thought. It's worth remembering that part of the reason why the court came to their determination on statutory construction was because there was an explicit reference to settlement within the terms of the BSA. So if Parliament has expressly said that settled cases do not come within the retroactivity provisions of the BSA, then the Court of Appeal decided, well, that's not necessarily true for ongoing cases. I think that has an internal logic to it.
Yeah, it does. And also, you may be aware that a working party involving a TCC judge, Mr. Justice Adam Constable, is starting to consider the BSA claims, because if there is going to be a need to amend, there's going to be a lot of needs to amend, and everybody's going to be putting forward the new amended cause of action added in, even if they actually think it's not going to be the strongest one in the pack that they've got, which is my view. It often isn't. It's the limp along, you know, the one that if you were starting pleading from the very start again, you would include, but you wouldn't pin your hopes on it. Right, I'm going to very quickly, I know we would run out of time.
Of course.
The upper tier tribunals, now I don't think most of us appear in the property chamber. I don't know if anybody in this room does. Because it's land. And the land lawyers and the leasehold and tenant lawyers tend to be quite a separate category of people. But these recent decisions have involved construction lawyers, and they have led to quite meaty decisions which are reported. And you can see they usually arise because the leaseholder or the freeholder is applying to the court to do something. And they have to do it in stages. It's a statutory regime for doing work on leasehold buildings if you're a freeholder. You have to advertise. There's no room for cutting down the periods of time. You have to consult. You have to get a certain number of quotes. It's all very well standardised and controlled. What this case concerned was an application to dispense from all that consultation because they just wanted to get on with the building works. And you would think, oh, well, that would be a good thing. Why would leaseholders not particularly want that? But what they also wanted was to be able to recover via the service charges. This one has a slightly convoluted route where the first tier tribunal gave the dispensation unconditionally. Okay, so you can get on with the works, and they kind of ignored the lease provisions, but they put in an order separately under Section 20C barring the recovery. Now, obviously, the freeholder had not expected that, and in fact, the first tier tribunal had not given the opportunity to hear submissions on that point. It had just put it in its decision at the end. They sought a review, and the first tier tribunal did review the decision. They reversed that 20C order, but then they said, okay, our dispensation will be subject to the condition that you are not able to claim under the service charge. Bit of a dog's breakfast in terms of how it was approached procedurally. Then the freeholder understandably wanted to get a review or an appeal. Permission was refused initially but granted by the upper tribunal, and the upper tribunal deputy president actually looked at this case. He went in detail through the Building Safety Act. You can see that they are really ready to grapple with the remediation contribution orders regime under the Act. Went through all the statutory tests to get to Schedule 8, and this is what Schedule 8 says: no service charge is payable under a qualifying lease. You have to qualify your lease in respect of legal or other professional services relating to the liability or potential liability of any person incurred as a result of a relevant defect. Again, you have to have a relevant defect. So the landlord had incurred these costs of professional services, and it was very unhappy. It felt it was unjust because it had done that, obviously expecting to get the money back via the service charge, and that had just been whipped out from underneath them. The landlord's position failed. It was rejected, and what the tribunal said was, this is a scheme of leaseholder protection, and therefore what you're saying is inconsistent with it, and so we're not going to give you the decision, and it should be capable of applying to costs incurred even before it came into force. So again, we've got this retrospectivity, which means all those headlines about leaseholders being required to make payments and being stuck in their flats, this should now start to unravel. It may take some time, but it should now start to unravel. A couple of other cases, again, where they have worked through, but the take-home message is that it doesn't matter if it was pre-act. They will still be applying it to the benefit of the leaseholder. The problem with this, and that all sounds very good and consumer-led, is that a lot of these freeholders are pension holders. They're pensions. So the pension funds are the ones who are going to get hit by this because they own these freeholds. It goes around and it comes around. Somebody has to pay. And this struck me as really encapsulating what we have. The world in which the costs of dealing with relevant defects failed to be recovered through service charges has been changed fundamentally by the 2022 Act. And then it's just saying that the purpose of Section 124, which is the key section for remediation and contribution orders, would just be undermined. If they could say it's unfair or it's unjust, that the statute has now changed all those contracts. So all those leases that have all those provisions which capture all of this defect work, it's not going to be applied. A couple more decisions. And again, this is the thing. Have the leaseholders paid for costs which ought to have been met by developers? That's the prevailing thought to walk away with. Because these leaseholders are getting aware of their powers now. It will be in these tribunals because it's only the first tier tribunal that has the power to make these orders. So it's not, don't look for them in the High Court. But this is going to be a very busy area. And ultimately, the freeholders, well, they're facing a statutory position. I got time to? Oh yeah, that's one of my favourite slides. It took ages to make. You have to see it.
Every component of this.
Yeah, exactly. We've kind of just been through all that. This is how I think of these claims, and the red on it is the Building Safety Act. It's kind of like coming round the sides and through the back. It's not the biggest feature. It's around the sides. One thing that is interesting is the Defective Premises Act and its interaction with net contribution clauses. It doesn't get as much attention as perhaps it should, but at the end of that act, there's a section that says anything in a contract or an agreement which attempts to restrict or limit the application of this act is void. And a net contribution clause arguably does exactly that. So if somebody is able, a developer's able now, because they are owed the duty under the Defective Premises Act, if they were to sue under that, the professional who normally gets the net contribution clause, in theory, does not have the benefit of it. Anyway, I'm digressing. I'm this late, oh dear. Right, the product manufacturer's claim. Sorry, we've got so excited at the other stages. These are the new ones that are coming through, and the Shepherd Construction against Kingspan is the biggie. It's coming to trial in October 2024. There's a whole roster of parties involved. There are 9 Kingspan companies that are listed on that claim, and it arises out of the Colindale Northern Quarter development. And what do they look like? Well, from what I can see, they're running this argument, the linear route, which I think you probably all know to death, which is i.e. the route for compliance via the building regs and ADB, is not possible because the materials weren't of limited combustibility, or the products didn't possess the relevant test, or they didn't meet the BR 135 route. Then there are the representations in product marketing literature, and I'm sure you've encountered all of those or some of those, saying it's suitable for use on those buildings, pretending class 0 was of any relevance whatsoever. Then the duty of care route, an interesting one, that the product manufacturer would owe you a duty of care. This is despite the fact that these buildings usually have a specialist cladding advisor, a specialist installer, an architect, fire engineering consultant. So getting off the ground on reasonably relied upon, not going to be easy, but it's pleaded. The assumption of responsibility by the product manufacturer. Now, on that case, the product manufacturer was very much involved and even gave a guarantee. So these are really these are really fact-dependent causes of action. They gave a warranty. You know, you're not going to have many of those, but if you do, there was a representation that they would issue a guarantee. This is what blew my mind. At some stage, Kingspan had NHBC saying, you've produced no evidence to demonstrate K15 could be used in buildings over 18 metres. We are going to be forced to advise our builder customers that it would decline to accept buildings using it. And they were threatened with an injunction. You know, you couldn't make it up, could you? NHBC being effectively gagged on building safety matters. The liability under the Act, that K15 didn't comply with that old cladding product requirement going through the Act, you know, again, difficult, but they're running it. And now you've got the ability to claim under the Civil Liability Contribution Act, even though you've not necessarily yet been sued by the actual property owners. So, sorry it ended up being a little bit of a canter through at the end, but that's all for the future and things to be thinking about. Thank you.
Thanks so much. Thank you.